With great powers come great responsibilities. Now, this power term as such has been in news and has been in top of the town, particularly with respect to this tussle that has been going on for a while now. Ever since 2018, this entire issue cropped up, and we, through this lecture, are going to talk about this. Now, through this session, we are going to talk about the curious case of NCT of Delhi. Let's begin to give you a brief introduction about myself. This is me, and this is my name, my qualifications, my years of experience, and the subjects that I have taught. Now, in 2020, the Madras High Court had, held that there was some role that was being in question with respect to Puducherry, the role of Lieutenant Governor of Puducherry and that of an elected government of UT. Now, Delhi is not the only case that has been put up. It is also the case of Puducherry, it is also the case of Delhi. These are two transient cases, and hopefully in the future you will also see a case put up with respect to the UT of Jammu and Kashmir as well. Hopefully, because why do we hope for that? Because then we will be able to interpret the constitution in a much more detailed fashion, in a much more nuanced manner. Now, what did the court rule? The Madras High Court gave a ruling, and it said that the government headed by the CM and the administrator, the Lieutenant Governor of Puducherry, they should work in unison and not in division. They should work together to run the government. Madras High Court had set aside the single bench judgment that earlier had come up with respect to Lieutenant Governor not having any right to interfere in the daily matters of elected government of Puducherry. And that made a point, and that point was within the federal units. If you have a government that has been elected, if you talk about UTs, for example, if you have an elected government, that does not set aside the relevance of a lieutenant governor. And that is where the Madras High Court judgment comes into play. The High Court had held that the administrator is bound by the aid and advice of the Council of Ministers. But then the power of the Assembly, which is contemplated under the Section 44 of the UTs Act of 1962. There have been two acts, one in 1962, one in 1963. Both of these acts are in reference in today's session. Make sure to watch it till the end. Now, if you talk about the case of Puducherry, it is a bit different from all the rest of the UTs. UT of Puducherry is headed by a lieutenant governor. It is the nominal head of that democratically elected government. You have a CM who's the real head or the real executive. De facto and de jure का concept यहाँ पर भी लागू होता है. Other UTs, they don't have elected governments or legislative assemblies. It is only in the case of Puducherry, NCT of Delhi, Jammu and Kashmir now, which are the three UTs that have democratically elected governments, just like other Indian states. But these democratically elected governments are different in the manner that rest of the states have governors. These have lieutenant governors because these are union territories. These are not exactly those federal units that are together forming the Union of India. It already includes, if you go through Article 1 and if you go through the entire Part 1 of the Indian Constitution, you would realize that in the explanation of Article 1, it has already mentioned, the Constitution has already mentioned that when we say India, that is Bharat, shall be union of states, it already includes the centrally administered territories or UTs. Already uska part explanation में दे रखा है. The state legislatures were a creation of the constitution, whereas UTs are not a creation of the constitution. ये difference याद रखिएगा. UT legislatures have been created by the government of UT's Act of 1962 and 1963 per se. The constitutional provisions have allowed for these acts to be passed, as well as the rules of business of the government of Puducherry, and in unison with that, the rules of business of the government of Delhi. They have been created to act as a bridge between the local government and the center. Today, we will be discussing the case not of Puducherry. This is only a reference. We will be discussing Delhi. Delhi is a curious case. Let's understand that. Let's begin with the thought. The Delhi conundrum. The Delhi conundrum started off not in 2022, not in 2023. It is an old situation. We will be talking about the historical evolution of this entire topic. Now, Supreme Court has looked into this problem of jurisdictional conflict that has happened between the CM or the elected government and the lieutenant governor. Article 239AA talks about Delhi as a UT and the kind of government it will be running. It is not to be administered by the Honorable President. It is not. Delhi is not, even though it is a UT, it is not to be administered by the President acting through the Lieutenant Governor under Article 239. 239 talks about a different procedure. It is a different procedure altogether for 239AA, which talks about administration of Delhi, particularly incorporated in 1992. The special constitutional setup for popularly elected assembly in Delhi with a council of ministers responsible to the assembly, just like you have responsibilities of governments, elected governments towards the legislature. Collective responsibility का concept लगाया हुआ है. Certain demarcation of responsibilities have been there between the lieutenant governor and the council of ministers, particularly in the case of Delhi. Let's understand what this bifurcation is. थोड़ा सा डिटेल में चलते हैं कॉन्स्टिट्यूशनल प्रोविजंस के. एज पर द आर्टिकल 239AA clause 3 sub clause A, the Delhi assembly can legislate on all those matters जो कि state list और concurrent list में है available, and they are applicable to the UTs. But as far as the lieutenant governor is concerned, he is empowered to talk about public order, police and land. इनसे related matters हैं तो lieutenant governor will have the authority. We will be talking about how this particular provision has been interpreted by the Honorable Supreme Court only recently. Now, what is the problem? The special setup that has been created, this has worked well, mainly because generally क्या होता है कि same party is in the center, same party is working in Delhi. But when times change, different politics happen. Central level पर अलग political party आ जाती है, state level पर अलग political या UT level पर अलग political parties आ जाती है. There are instances of having differences of political opinion, and it is then that the lieutenant governor, which is appointed as a position appointed by the center, comes in a tussle. A turf war starts off between the elected government and the appointed executive, the nominal head and the real executive. Now, presently, the Honorable Supreme Court has looked into two main issues. Now, these two major issues are particularly whether the elected government is the final authority in respect of matters assigned to it by the Constitution. कौन से? Except public order, except police, except land. Except these three things, if the government is handling matters into with respect to all the powers assigned to it by the Constitution, what is the final authority? Does the lieutenant governor have authority there as well or not? That was the first thing. Second thing, will the lieutenant governor have primacy when there is a difference of opinion? अगर लेफ्टिनेंट गवर्नर और आपके रियल एग्जीक्यूटिव जो इलेक्टेड हेड्स हैं उनका काउंसिल ऑफ मिनिस्टर्स का आपस में एक पब्लिक डिस्कोर्स में या अदरवाइज बिहाइंड द डोर्स अगर कभी भी कॉन्फ्लिक्ट ऑफ ओपिनियन आ जाता है या डिफरेंस ऑफ ओपिनियन आ जाता है, who would be the final authority? Who would have primacy? Now, why should the council of ministers be given the power? ये रीजन समझते हैं and then we'll move on to the verdict. The final authority as per the Article 239AA Clause 4, the Council of Ministers will have the executive power to execute all matters relating to everything except, I'm repeating, public order, police and land. these three things. Article 239A Clause A says that if the administration of the NCT, National Capital Territory, cannot be carried on in accordance with the provisions of 239AA, the president can dismiss the Council of Ministers. So it is going to be the authority of Council of Ministers to make sure that everything that is being run as a matter of administration or is being executed, all laws being executed should be under the purview of 239AA. That means 239AA will have primacy. सबसे पहली चीज कॉन्स्टिट्यूशनल प्रोविजन को सर्वोपरि रखना होगा, सबसे पहली चीज। उसके बाद अगर ऐसा नहीं होता है तो the honorable president will have the authority to dismiss the council of ministers. Further, the second clause talks about that the council of ministers shall be collectively responsible to the assembly, which makes it a responsible government as per the purviews of rule of law. रिस्पॉन्सिबल गवर्नमेंट का मतलब ये नहीं कि वो जिम्मेदाराना सरकारें हैं, नो, जिम्मेदार सरकारें। और रिस्पॉन्सिबल गवर्नमेंट मींस दैट इट इज अ गवर्नमेंट दैट इज लिमिटेड इन इट्स कैरेक्टर and the powers of the government are not going to be exercised in any form of arbitrariness. No absolution, no form of absolute power or despotism would be allowed. ये उस तरीके की collective responsibility है which is a part of rule of law in India. Now, the Council of Ministers are responsible for the Delhi's administration, and if it fails in its functions, they can be removed by the president. It is a very rare case that it is allowed, because otherwise there are very limited checks and balances. All the checks and balances that exist on, say, the executive at the central level are parliamentary in nature. Be it the estimates committee, public accounts committee, all the committees that have financial checks and balances, and the parliament having, the legislature having the political checks and balances in place for the executive. Here, the executive head of the state, which is the president, the honorable president, is able to remove the council of ministers. This is a curious case of Delhi, Puducherry, and various other, including Jammu and Kashmir. तो यहां पर यूनियन टेरिटरीज, यूटीज का कॉन्सेप्ट जो है प्ले में आ जाता। The Council of Ministers, although cannot be removed for the breakdown of constitutional machinery unless they are vested with the powers to take final decisions on matters of administration. That means कि जिन जिन matters में Council of Ministers जो है final authority है, that is where there can be a breakdown of constitutional machinery, and that is where the administration, or rather the executive, can be removed by the president. Otherwise, breakdown of constitutional machinery nahi ho raha hai, just because if you have lieutenant governor and council of ministers sitting not at the same side of the table but in front of each other, against each other, that does not bring you to the point of constitutional machinery breaking down. That is not the case. It is absurd to think that the Council of Ministers will be removed for the failures of the Lieutenant Governor, for example. So all the powers that are vested in the Lieutenant Governor, they have been mentioned in Article 239AA. And vesting of all powers in the Lieutenant Governor in respect of matters which come under the jurisdiction of the Assembly is not in conformity with the scheme of the article, क्योंकि वहां पर सिर्फ और सिर्फ तीन चीजों की बात बोली हुई है। कौन सी तीन चीजें? कमेंट्स में बताना। प्रिमेसी किसकी रहेगी? The second question that was answered by the Honorable Supreme Court. Now, the second question that was answered, that was whether Lieutenant Governor will or will not have the primacy whenever there is a tussle. A Lieutenant Governor is motivated by political considerations, given that he is a appointee of the center. He could disagree with many decisions of an elected government and he may refer them to the president. That is well within his purview. So such a provision in the proviso to clause 4 of 239AA, इसको कैसे पढ़ा जाता है? So it is the proviso to the clause 4 of article 239AA. It virtually nullifies the executive power which is vested in Council of Ministers. Council of Ministers. See, guys, even though the Honorable Supreme Court has come up with a verdict, it cannot undermine the provisions of the Indian Constitution. 239AA Clause 4 proviso still exists. After all, the purpose of constitutional amendment should be to provide a democratic government for Delhi, not to enhance the powers of Lieutenant Governor. That was the purpose, to provide a region some form of political justice, to give the political aspirations of a unit of land, or people of a unit of land, certain wave of political justice. So, in regard to the matters of governance, other than that, in the discretionary list of the Lieutenant Governor, Council of Ministers should be left free to exercise their executive power. लेकिन subject to the proviso of clause 4 239 AA. All right. Now, let's come up and understand the entire timeline of this situation. There was a judgment by the Delhi High Court in 2017. That was the first point of time where there was some form of issue being cropped up. Now, the 2017 Delhi High Court judgment held that for administration purposes of NCT, LG is not, Lieutenant Governor is not bound. He's not bound by the aid and advice of Council of Ministers. That means you have, by the Delhi High Court judgment, created a separate legal entity in the Lieutenant Governor post, अलग कर दिया काउंसिल ऑफ मिनिस्टर्स से, which is not true in the case of all other governors or all other, even though they are center appointees. You cannot divorce them from the aid and advice of council of ministers. Yes, there are certain discretionary powers to other governors of the states, that is not denied, but for example, if you talk about the honorable president, he is bound by the aid and advice of the council of ministers. Now, on an appeal, the Honorable Supreme Court in 2017 itself, the matter was referred to it, and the matters was to decide the interpretation of Article 239AA. Then a judgment came up in 2018 by the Honorable Supreme Court. A five-judge constitutional bench had unanimously held that the Lieutenant Governor of Delhi was bound by the aid and advice of the elected government, and both needed to work harmoniously with each other, hand in hands. 2019, another judgment came, but this judgment came by a two-judge bench, and it had a split verdict, because of which the entire issue again cropped up. One judge ruled that the government has no power, the elected government has no power at all over the administrative services, and the other judge had said that the transfer or posting of officers in top echelons of bureaucracy, like the joint director and above or so, can only be done by the central government. So even though it was a split verdict, even the other half, or the against wala jo verdict tha against the center, still sided with the center in the matters of transfers and postings of senior or higher officials, the higher echelons of bureaucracy. The 2022 case that was put up, and recently the judgment came for that case, the center on 27th April had sought a reference to a larger bench and argued that there was a need to need to understand the power to make transfers of postings of various officers. And इस verdict के बाद immediately हमारे दिल्ली के सीएम साहब ने एक important IAS officer की posting जो है बदल दी, right? Now, it was all about transferring and posting of officials. It started off with that, but it also cropped up the matters of constitutional importance to understand the Indian federalism, जिसकी वजह से ये वाला जो वर्डिक्ट है हमारे लिए रेलिवेंट. The officers in Delhi, how their postings and their transfers would happen, ये चीज चर्चा में रही. The court agreed that the limited question relating to the scope of the legislative and executive powers of center and NCT of Delhi, the government thereof, with respect to the term service is concerned, it needs an authoritative pronouncement, and that is why a constitutional bench had been set up in terms of Article 145 Clause 3 of the Indian Constitution. उसके तहत constitutional bench को matter transfer कर दी. What were the arguments and counter arguments that were cropped up during this entire tussle in front of the Honorable Supreme Court, the Honorable CJI, and various other honorable judges of the Supreme Court had been listening to? The arguments for or in favor of. They said that center has consistently maintained, and they were in favor of that because Delhi is the national capital, it has been the face of the country, it is supposed to be controlled, the administrative services particularly, which include appointments and transfers, it is supposed to be controlled by the center. The counter argument is a bit more philosophical in nature. It is a bit more not procedural, because the favor arguments जो है वो थोड़ा procedural है कि it is going to be pertinent, it is going to be prudent to have the center handle all these things. But then the counter argument is based on the interest of federalism. It is based on the democratic principles that have made sure that the entire people or the entire people of the region, they have been given certain hue and a certain level of their political interests have been accepted and given a certain voice through a democratically elected government. Delhi government has also contended that the recent amendments to the Delhi Government of Delhi Act 2021, they violate the doctrine of basic structure of the Indian Constitution. That was the counter argument कि ये basic structure doctrine के खिलाफ जाता है. But this counter argument that it goes beyond or violates the basic structure doctrine, I can tell you for sure that given that you understand the Indian constitutionalism, and if you don't, then you should watch my lectures on constitutionalism. I have been delivering these lectures on an academy platform. Guys, do not miss those lectures. And if you have not yet started to follow me on an academy, make sure to do that right away. Now, let's talk about the governance model of Delhi and then understand what is this basic structure doctrine talking about and what is the verdict. Now, this governance model has been christened as the NCT region model and the model of Delhi. It is working well with respect to, say, for example, education sector and many other things. The status of Delhi, it being a UT under first schedule of the Indian Constitution, and has been delivered with this article, an amendment under the Constitution, Article 239AA, which was added by the 69th Constitutional Amendment Act. This article declared the UT of Delhi to be administered by a lieutenant governor. That means the administrative head is the lieutenant governor, who would work on the aid and advice of the elected legislative assembly, which would have council of ministers, whose aid and advice the lieutenant governor will be bound by. लेकिन जो clause है ना aid and advice का, it pertains only to the matters on which elected assembly has powers under the state list and concurrent list. There are certain exceptions to that, and that was enshrined in the constitution in the manner that public order, police, and land in matters may lieutenant governor will have discretion. In fact, the article itself notes that lieutenant governor has to either act on the aid and advice of the council of ministers, or he is bound to implement the decision taken by the president if a reference has been made to him by him. अगर लेफ्टिनेंट गवर्नर ने प्रेसिडेंट को रेफरेंस दे दिया तो जो प्रेसिडेंट साहब डिसीजन लेंगे वो ही इंप्लीमेंट होगा, फिर उसको एड एंड एडवाइस सुनने की जरूरत नहीं है. Article 239AA empowers the lieutenant governor to refer a difference of opinion on any matter, not just on public order, police and land, not just on these three. किसी भी मैटर पे अगर उन्हें लगता है कि मैटर को हमें प्रेसिडेंट को रेफर करना है तो then he can. Thus, there is a dual control between the lieutenant governor and the elected governments, and that was what was thought about by that constitutional amendment. ये हमारे संविधान का हिस्सा है. The verdict. What does the Honorable Supreme Court think about this entire tussle? The Honorable Supreme Court has held that the legislative and the executive power over the administrative services, excluding of course public order, police, land के matters को छोड़ के बाकी सब चीजों में लेफ्टिनेंट गवर्नर shall word use किया गया है, shall be bound by the decisions of Delhi government. That means he is now made to be bound by the aid and advice of Council of Ministers of the UT of Delhi and the Legislative Assembly thereof. The Constitutional Bench has disagreed with Justice Ashok Bhushan's views from the 2019-2020 verdict, which was a split one, where he had said that services were totally outside the purview of Delhi government. ऐसा नहीं माना है, ये कह दिया गया है कि नहीं ऐसा नहीं हो सकता है. The services will come under the purview of Delhi government, except of course public order, police, and land. These three things. The Constitution Bench has said that the principle of representative democracy, the Delhi government is an embodiment of that principle. The Delhi Assembly is given powers to legislate or to represent the will of the people. और उस चीज को आप उसका गला घोट नहीं सकते. You cannot kill that. Therefore, this amendment, this Article 239AA of the Constitution must be interpreted in the interest of representative democracy. पार्टिसिपेटिव वाले पोर्शन में अभी नहीं जाएंगे, उतना इसको कॉम्प्लिकेट नहीं करना. This quote comes from the judgment itself. The Honorable Supreme Court has observed that the ideal conclusion would be that the government of NCT of Delhi ought to have control over services. नहीं तो, of course, subject to the exclusion of subjects, because the legislative and executive power of NCT of Delhi, over the entry 41, which is services, shall not extend over services related to public order, police, and land. The legislative and executive power over services such as Indian administrative services, the joint cadre services, which are joint cadre में आपका UT cadre आ जाता है, which are relevant for the implementation of policies, shall lie with the NCT, because if it does not, then how can you expect the government of NCT of Delhi to run all the policies? कैसे आप इमेजिन कर सकते हैं कि अगर पॉलिसी बना दी एक रिप्रेजेंटेटिव डेमोक्रेसी के अंदर, एक इलेक्टेड रिप्रेजेंटेटिव फॉर्म में इलेक्टेड गवर्नमेंट ने, हाउ वुड यू implement those policies if you do not have control over the implementation process? Under entry 41 list 2, which is the state list, the lieutenant governor shall be bound, shall word use ho gaya, shall be bound by the decisions of G government of NCT of Delhi, as explained above in the verdict. To clarify, any reference that is made to the lieutenant governor over the services, excluding of course public order, police, and land in relevant rules, shall remain that lieutenant governor is acting on behalf of the NCT Delhi government. If a democratically elected government is not given the power to control the officers, the principle of triple chain of accountability will be redundant. आप कैसे accountability ensure करेंगे if the officers stop reporting to the political bosses, to the ministers, जो कि हम हमेशा डरते हैं ना, as aspirants, we always think that there should be no authoritative control of the political heads or the political chiefs of ministers, for example. But that is against the ethos of Indian constitutionalism. In fact, you should be in a manner controlled by the political bosses, because political bosses are representatives of the people of this country that you are bound to serve. Of course, there are certain nuances about corruption, about malpractices in political arenas. वो सब ठीक है, but in a utopian world, this is how things are. Executive is answerable to the political heads. If you are a student of public administration, you would know that Woodrow Wilson had talked about this dichotomy. Woodrow Wilson had talked about this dichotomy. Now, if services are excluded from the legislative and executive domain, how can you imagine the ministers, how would they be able to control the civil servants who are supposed to implement their decisions? If the officers feel they are insulated from the control of government, will it not dilute the accountability? The Honorable Supreme Court said that it would, and it would affect the governance. So the Constitution, CV means Constitution Bench, remarked that in a democratic form of government, the real power of administration must rest on the elected arm of the government. Now, the Constitution Bench has also emphasized that the Delhi government, similar to all other states, it represents the representative form of government. It is the will, the political interests of people replicated or mirrored in the form of creation of the legislative assembly. And further, the expansion of union's power will be contrary to the constitutional scheme of things. In fact, Honorable Supreme Court ने clarify किया that 239 AA is only meant to balance the interests between Union of India and the Delhi government. The executive power of the union in state over various matters, चाहे वो union से related है, चाहे वो state से related है, they can legislate, and it is limited, of course, to ensure that governance of the state is not taken over by the union, and that is why their powers have been delegated. This would completely abrogate the federal system of governance अगर आप उनसे ये powers छीन लेते हैं, and it would be against the principles of representative democracy. The principle of democracy, the Honorable Supreme Court held that federalism, along with it, form a part of basic structure. Principle of democracy and a principle of federalism. ये principles हमारे basic structure का part है. Federalism ensures survival of diverse interests, accommodates diverse needs and political interests of people of this country. तो इस वजह से वो basic structure का part भी है. Now, trust me, guys, when we say that it is a part of basic structure, it is not the code, quote unquote, mentioned in 239 AA, for example, that is to be considered as a part of basic structure doctrine. It is the principles of federalism that are ensured by that article 239 AA. That means that whatever has been mentioned in 239 AA and the coincidental articles shall be upheld. तो यहां पर सुप्रीम कोर्ट ने कह क्या दिया है, थोड़ा सा इसको समझ ले. The Honorable Supreme Court has basically said that everything and anything mentioned in the Constitution should be upheld. That is it. Why should it be upheld? Because it is a part of basic structure doctrine. What has been mentioned, थोड़ा simplify करके बता रहा हूं, all those students who have not yet gotten the gist of it. Number one thing, the lieutenant governor has discretionary powers with respect to public order, land and police. These three things. Comment में आ चुका होना चाहिए था वैसे अभी तक. Apart from that, the lieutenant governor will also have the power to refer any matter to the president. True. But the lieutenant governor will be bound by the aid and advice of all the rest of the items of that entry in the list too. All the coincidental matters. It will be the Honorable Lieutenant Governor will be bound by the aid and advice of Council of Ministers, which are the government of NCT of Delhi. That is the case. That is the end verdict on what should be the way forward. It is the federal nature of the Indian Constitution. It is a part of basic structure doctrine. You should not alter this. You should not hamper this. A diverse and a large country like India, you cannot have centralizing tendencies everywhere. So you will have to delegate certain level of autonomy to the federal units to make sure that it functions smoothly. Extreme political centralization would be chaotic, and it, or in fact, not just extreme political centralization, extreme political decentralization would also be chaotic and can both lead to weakening of India's federalism. Slight centralizing tendencies and more autonomous nature of the federal units so that they can handle stuff which is relevant for them is the balance that we have created. The satisfactory, lasting solution of this vexed problem is found by this verdict, but it needs to be found not in the statute book, but in the conscience of men in power. थोड़ा बैलेंस हमारे इंसानों के बीच में चाहिए. Collective responsibility, aid and advice are the pillars of democracy. It should be used in the right manner and should be allowed even in Delhi. That is all for today. If you have understood the verdict, Please let me know in the comment section if you have any doubts. I would be referring this verdict in my lectures on Unacademy platform. If you are following me on Unacademy, then it is fine. If you have not yet followed me on Unacademy, me through Sriram Guys on Unacademy platform, we are bringing to you a lot of stuff, a lot of information. Make sure to follow us. That is all for today. Thank you. Take care. God bless you all. Bye bye.